right can also be heard on the issue.
Let's let counsel finish it first, I think.
Yeah, Your Honor, and I have no problem cutting right to the quick here and shortening things up with these issues, but what we're trying to show to the court is the importance of, we disagree with the county registrar's opinion that the code sections stand for the fact that Janet Nguyen's campaign got to decide the recount. Ms. Mercury's testimony supports the concept that in order for a full recount to be conducted, you have to rely on the official record, and that in this case is the VVPAT. So that's the relevance, and that's what we're talking about. And this evidence actually shows the court why this is so important. The fact is that it actually could lead to votes that weren't counted for either candidate. But I can cover this area quickly, and I think I'm finished with this area, and I can move on if that's what the court wishes.
The only problem, the point though is that Ms. Mercury may be 100% correct. The question is whether the comments ought to be addressed to legislative committee or subcommittee or something as they rewrite the elections code, whether in the humble vineyard in which we toil today, somehow we're going to decide to change the election law or how it's applied or something. But go ahead. Did you want to make a statement for the record?
Yes, Your Honor. I think to ask Ms. Mercury to opine as to the appropriateness of using a certain method of recount is asking for legal conclusion beyond the scope of her expertise, and also focusing on the 9.2 failure rate, and by looking at 2 specific precincts out of the hundreds that we have, I think is isolating individual incidents and then using that as a number to applicable to the entire election. I think that's erroneous.
All right, so that comment will be on the record. Go ahead.
Sure, Your Honor. Do you wish for me to comment?
Go ahead and ask whatever you want to ask, and I'm sure there'll be an objection.
Yes, Your Honor.
Counsel feels it's improper or something.
Madam Court Reporter, can you read back the last question I had?
Okay, and in your opinion, if Mr. Nguyen's campaign had been allowed as a requested to review the VVPATs, would it have been able to challenge these votes that possibly were part of this failure rate?
Again, Your Honor, same objection. The Nguyen campaign was not a party who filed the declaration requesting the recount. It simply was not their prerogative to decide how the recount was to be conducted. And it calls for speculation as to what might have happened if something which was legally impossible did.
We would join in that objection.
Your Honor, the court indicated earlier that it had that one of the issues that it had an interest in is finding out what you could have that if you look at the VVPAT, what you could find. And that's what this question goes to. It goes to exactly what the court wanted to know, which is the argument here is, and they've raised it specifically in their papers, they're saying, well, you haven't introduced any evidence that if the VVPAT was counted, that things could have come out differently. And the purpose of this testimony was trying to elicit is to answer that exact point and go to what the court's asked about, which is, okay, if you count the VVPAT, what would be different? One thing that we've seen is she's saying that the only place where you can find what happened with write-ins is on the VVPAT. I mean, there were hundreds of ballots in the paper side where someone filled in the bubble for, let's say, for the write-in and wrote in Janet Nguyen or Trung Nguyen. Those were all counted. That's very common. What this is intended to elicit is, what about the same situation on the electronic ballots? If someone just filled in the bubble for write-in and put in Trung Nguyen, where would that be found? And if the only way we can elicit this testimony is through a witness that says this is how the machine works, and if this set of facts happened, then, and we'll put on somebody else to say it did happen, we're not asking her to testify that there were ballots like that we'll get from other witnesses, but what we are asking her to say is, if someone did that, where would you see it? And the purpose is to elicit testimony that only goes, the only place you could find that is on the VVPAT. So that's the purpose of the testimony. We're not asking you to speculate. And in fact, what we're saying is, we're not asking as county council suggested, to control the recount. We're simply saying, if it was counted manually, so you looked at the VVPAT, what sorts of things would they've been able to see and challenge? That's it. And I think that that's a totally appropriate testimony, particularly since they're the ones that put at issue this evidentiary burden that they're claiming we have to meet.
First, the challenger has the right to pick the type of recount. A challenger could say, I want a total electronic recount,
Correct.
in which case we'd never be talking about VVPAT.
That's correct.
Your thrust of your argument, as I understand it, that you would say that once you choose a manual recount, yet the whole recount has to be a manual recount.
That's one of our two arguments. The second argument is, if you request an electronic recount, and some of the ballots were taken on a DRE, then under 19253, those have to be counted. You have to count the paper. You cannot do it straight through electronic count, because 19253 just simply doesn't allow it. It says on those, you gotta look at the paper. That's our second argument, because the specific controls over the general, and it specifically says it's not a full recount unless you do that. That's our second point. So we have two arguments, which is even if they requested a pure electronic recount, it wouldn't be a full recount if there are DREs involved. Many counties don't have DREs, so then it wouldn't be true there. But in a county where they're using DREs with HAVA money, federal money, they've got to count the paper, irrespective of whether you ask for electronic or manual.
Your Honor, if I might, Your Honor, a couple of things. First of all, the code doesn't say that. The code says at 19253-2, the voter verified paper trail shall govern if there is any difference between it and the electronic recording during the 1% manual tally or full recount. It doesn't say a manual recount, so they're wrong. They're flat wrong there. Second of all, going to the specific point here, the witness is asking, speculate. What would you find if you opened the birthday present? I might find a pony. I might find a horse. I might find an Easter egg. That's pure speculation. There's no evidence that's been offered or that this witness has relied upon which shows that there's a malfunction with the computer system, that anybody's tampering with the computer system, that it's been corrupt, that the 1% canvas was inappropriate or incorrect. There's nothing there. This is pure speculation. And all it's designed to do is muddy the waters. And it's highly inappropriate at this time.
All right, now, Mr. Gleason, you're on your feet.
Final statement very quickly, Your Honor. The issue under 16100 is whether or not there were errors sufficient to change the result. In this particular case, the statute at issue, Election Code Section 15632, specifically says that a recount is not a full recount unless all the precincts are counted. And that has to mean counted as required by law, Your Honor. And if they aren't, Your Honor, they are null and void. The issue is not whether we can demonstrate 124 of these votes in fact were counted in one way or the other. It is to demonstrate, Your Honor, that the method that was selected was improper and therefore caused a defect in the process. That is the issue.
Selected by the challenger?
Correct, and ratified by the registrar pursuant to what would be included as Exhibit I to the Kelly Declaration of March 2nd, which was a letter confirming
Challenger
that.
has, what, 3 days to make a challenge?
5 days, but yes.
5 days, and no challengers aware of all these intricate aspects of it.
And we requested this information pursuant both to a letter request and a subpoena.
All right, allow what we're going to have to do. Mr. Page, you have some brief remark you want to
Only the point, Your Honor, that this is not relevant because as to these 124 votes, there's been no evidence, no testimony that these were errors. There's no proof that this is a failure rate. The witness does not know whether 124 people, in fact, went to the polling place and entered Thomas Jefferson or Mickey Mouse or Jesus Christ. Until that testimony is given, until that proof is established, this is speculative. It's irrelevant to the issue now before the court as to how the registrar conducted the recount and whether that was proper. Without that further evidence that there was a problem with how these other votes were recorded, this testimony doesn't go anywhere. It's unrelated to the issues before the court.
All right. All right. Objection to be overruled. I take it we're near the end of this.
Correct, Your Honor.